Hello, my name's Chris Bentley, and along with Hirsch Perlis, we are bringing you edition number 2 of the Lawyering from Home series. Hirsch and I co-founded the Legal Innovation Zone 5 years ago, and we did it to help build better legal solutions for consumers. We incubate companies that want to do something innovative in law. We support organizations that are looking to advance their innovation agenda. And we have a project, a family law project underway at the moment to try and make sure that consumers get what they need as early as possible. We are delighted that you have joined us. I'm going to turn it over in 2 seconds to my co-host, Hirsch, to introduce our first of 2 guests. Just a few notes. We're in interesting times, very challenging times. I hope, first of all, that you're all safe. Secondly, if the technology goes wonky, don't worry. We'll figure out how to fix it. That's almost inevitable. So we'll innovate our way through that. Third, if you have questions, fire them through on the chat line. We'll be able to manage them and we'll ask them of our guests at the appropriate time. And finally, this will be recorded and we will be posting it on the Legal Innovation Zone website probably tomorrow. It does count for 2 hours of professionalism, according to the Law Society. So with that, Hirsch, why don't you take it away?
Thanks, Chris. Welcome, everyone. This is very exciting, our second session of the family Lawyering from Home. Today we have 2 great speakers. First, we're starting off with Jennifer Reynolds. Jennifer is a family law lawyer, collaborative law practitioner, and a mediator. She is the founder of Fresh Legal in 2015 with a focus on out-of-court solutions. Fresh Law is not only unique in their values and alternative solutions, but also one of the many reasons we have Jennifer speaking today is because she set up Fresh Law as a more remote law firm. She sees clients remotely for many years now, so what's happening right now is nothing new to her. So she'll be describing really running it of what she's been doing for many years. And what I found most importantly is, and maybe she'll talk about it, maybe she won't, is that if she wasn't a lawyer, she would own a stationery store. So maybe she'll get into that as well, or we can ask questions about that at the end. But here is Jennifer.
All right, so I get to take over now, I think, and I'll do my screen share here. Bear with me for 2 seconds. All right, you should all be able to see the PowerPoint and maybe me. Hello. Okay, so yes, if I did not lawyer, I would definitely own a stationery store with lots of fancy letterpress paper and printing. But alas, I went to law school. I also have to apologize in advance. I have no adorable children and no adorable pets that are going to make an appearance during the webinar. So you've just got this. I founded Fresh Legal, like Hirsch said, in 2015. We're not entirely remote, but part of my goal is to change the way that lawyers practice law and provide remote options. So we have a physical office space. We all have offices there, but we're all able to work from home if and when we need to, and we have that flexibility. So we were really lucky. When this hit, we were able to take our computers home and work pretty seamlessly. So my first sort of warning to you or caution is that I have been doing this for a long time and some others have been doing this for a long time. So it was pretty seamless for us, but it did take some time to set up. So be gracious with yourself, be kind, realize it's going to take you some time to get the systems in place that you need. But at the same time, none of this was overly difficult to set up. So know that you can do this. It is something that is relatively easy for you to set up. And it's something that you can probably put together over the course of the next few days. I'm going to share both tools that we use and some tips and tricks about working from home. As far as tools, it's definitely going to have a bias towards the tools that I use in my practice, with the proviso that there's lots of tools out there that do the same thing, and you're going to need to find the one that works for you, the one that you like the best. But ultimately, it comes down to what a friend of mine said recently, was that what was innovation a few weeks ago is now table stakes. It's now sort of a ride or die situation. We've got to innovate a lot more quickly than maybe we would have felt comfortable doing otherwise. And the other caution in this is that if you're watching this in the future and we are all back working in our offices and the pandemic situation is over, there are some tips on here and some circumstances that apply only to our current situation. So there's remote work, and then there's remote work during COVID. And during COVID, there are some leniencies, some changes to how we can do things according to the Law Society that don't apply at other times. So just keep that in mind. So the first thing I wanted to share is just some basic nuts and bolts. The first tips I have are just home office generally, quickly, not family law specific. I asked my team what it is that they would say. Lots of votes for making sure you have a good chair and a good desk. Don't be working in a couch or on your bed or whatever all the time. You will be in pain and you won't be as motivated. Try as much as you can also to mirror your setup at your home office to your work office. So if you have your raised laptop and a second monitor and a scanner on your desk, get those pieces of tech into your home office as well. And maybe get yourself a treat or two for your home office that's maybe a little nicer even. Get yourself a slightly bigger monitor, get yourself some nice art to look at, things that'll motivate you to go into that space when maybe Netflix is a lot more tempting at this time. First nut and bolt tech-wise is some sort of practice management software, which I'm sure most of you have set up already. But what you might not have right now is a cloud-based system. So we use Clio at our office, and that's entirely cloud-based. And what that allowed us to do is a completely seamless transition. There was no panic of backing up data from an on-site server onto our computers and bringing it to our offices at our house. There was no panic of setting up the go-to meeting, go-to desktop sort of setup. We were able to take our laptops, go to our houses, and keep on working. The team is able to continue working together, and we're able to continue billing and doing payments and all of that stuff as normal. The other cloudless thing that I would suggest looking into if you don't already have is cloudless bookkeeping software. So depending on your practice management software, it may or may not have any bookkeeping or accounting built into it. So we use a software called Xero, Xero, and it links up with our Clio account. And because it's cloud-based as well, our bookkeeper keeps working. Our bookkeeper doesn't come into our office. In fact, we've been working with her for several years, and she works from her home, and she's able to access everything that she needs because it's all in the cloud. You do need to continue to comply with all the rules and the bylaws that the Law Society has put in place, even though we're in a unique situation, and COVID and the pandemic has certainly caused a lot of changes to our lives. You need to make sure you're continuing to comply. You're doing trust reconciliations, you're complying with the rules for electronic transfers and that sort of thing. And I'll talk about those a little bit more. So the first challenge you're going to face is paper. So much paper, right? Family law files, especially continuing records. If you're going to court, how do you gather the documents from your client? How do you store the documents for yourself? And again, I'm going to say it over and over, cloud-based storage systems are key. Something like Dropbox will change your life. And having a desktop scanner on your desk in your office, and when you get back to your real office, having a desktop scanner there so that every piece of paper that comes into your office is scanned and it's named in a consistent manner in a file folder system that makes sense, that anybody else could understand. So we have a file for every client. Within that file, there is, if we're in court, a continuing record file, and every document is named with a number at the start, which is the tab that it is in the continuing record. So we have 1-application, 1A, affidavit of service, 2, answer, and so on and so forth, right? When we name correspondence, we make sure we put the date at the beginning. So when we organize the file, we see those numbers go in sequential order. For getting documents from your clients, that's maybe the unique challenge at this point, right? I don't think there's very many of us who would be eager to tell a client their home address to come drop things off. You may still be able to have things dropped off at your office that you go and pick up if that's a safe option for you. Or you might need to look into doing a shared Dropbox or a shared Google Drive, something like that, where it's a safe, secure way that they can upload things, and teaching your client how to scan things properly if they're not doing so. We've all experienced the, taking a picture of a document and they send you a JPEG and they've opted into the small size and suddenly it's tiny and you don't have the data you need, can't read it. So teaching them how to use their iPhone and things like that, or maybe using online forms. And then an overarching warning, I'm not going to go into it in great detail because there's a lot of great resources out there, but maintaining confidentiality and protecting your information is of course key and really important at this point. Making sure that your home office is secure, your internet is locked down, that you have a unique identifier, your home network, that you've changed the name of that from the default to something unique to you and something that doesn't identify it as a law office and that has a strong password protection on it. And encrypting your laptop and making sure that you're not using public Wi-Fi. So now I'm going to move into a bit more of a following the file linearly, with the proviso that there's a lot of things that we do all through the file. So I might tell you about how to get paid at the retainer stage, but those rules are going to apply as we move through. So when you can't meet a client at your office, when you can't have people drop in as they might have done in the past, what do you do? How do you go about connecting with those clients for the first time? These are all tools that we already use and are advantageous in the current situation. So we have a contact form on our website. A caution with respect to the contact form that I just learned is making sure that it doesn't accidentally break without you knowing it. Make sure you check your spam folder in case your contact form emails are going into that spam for some reason. And putting in a safeguard for what happens if that contact form doesn't get to you. So we have an automated email set up that once somebody fills out a contact form, we have our system send them an email automatically that says, thank you for contacting us. Here are some resources you might find useful and we'll be in touch soon. And we've added as a safeguard on our website, when you hit submit on that contact form, it now says, thank you for submitting. Within 30 minutes, you should get an email from us. If you don't, please email a particular email address so we can make sure nobody's falling through the cracks. We also schedule, as much as possible, our cold calls. So there's a tool on our website where somebody can go on and find a time that works for them to chat with a lawyer. And that's basically replacing the cold call feature that keeps people from interrupting our day, which was one of the original reasons that we did it. It keeps it from the phone tag. And if you're at home and you don't have your office phone set up, you don't want necessarily people calling you. You can use that to schedule a time to have you call them and know that they're available and that they've given you a number that's safe for you to reach them. And then the last piece that's important too is some sort of cloud-based CRM, which is a customer relationship management software. That's something that lets you track who has contacted you, whether they've hired you, what the follow-ups have been, and all of those details. And when, again, it's cloud-based, everybody on your team can get at it from wherever they are. So I do have a couple that we use. So there's screenshots here of our Acuity scheduling software. And this is useful at all stages of the file. This is just the first time we use it for an initial phone call, but our clients also use it whenever they want to call us or book a meeting. They can go on here and find a time that works for them. You can set different appointment lengths, different follow-ups, reminders. You can set different limits on the back end. So you could say, I'm willing to talk to up to 4 people per day on the phone, but I'm only willing to have 2 in-person meetings per day. Or I'm willing to meet with people in person on Mondays, but not on Fridays. And you can set your business hours, and it links to your calendar to block your availability. As with everything else, there's a lot of other tools available here too. And then we use Clio Grow for our CRM. So I stole this screenshot from their website. I think I saw a Clio person on here. Thank you. We use this to track the status of everybody that comes into our firm as a lead. And we have a whole bunch of different stages that they go through, from initial contact to actually retaining us. We have a whole bunch of different categories for why they didn't hire us, if that was the case, so we can track that. And we have automated follow-ups and templates and tasks and everything. So definitely worth checking that out. You might be familiar with Lexicata. That was what its name was before Clio Grow purchased it. Then the next big question is your initial meeting with a client, right? You don't have an office that they can come to, whether it's because of the current situation or because you just choose to work in a remote environment. So how do you have that first meeting with the client? The first big thing is an intake form. Many of you probably have intake forms, and some of you might be used to using paper intake forms. They might come to your office for the first meeting, and they sit down in the waiting room, and the receptionist says, welcome, here's a cup of coffee, here's an intake form and a clipboard. Fill this out while you wait to meet with the client. Provide us with your client ID and all of those pieces of the puzzle. You certainly could fairly seamlessly move to using that paper intake form as a PDF. You could build something in Microsoft Word that you print off or make into a PDF, or you could just scan the one that you have right now, right? You don't need to reinvent the wheel. But if you have time, now is a great time to move to using online paperless intake forms. I moved to using these so that I could start to use required fields, to be honest, because I was tired of looking up my clients' postal codes. And when you have an intake form on a website, you can have a required field, and then they have to answer it before they move on, right? So you can use this to make sure that you're gathering required information by the Law Society, all your client identification information, like their address and their employment, put it all on that form, right? You can also use follow-up or conditional questions so that questions only pop up if they need to, right? In family law, we're working with some couples that are married and some couples that are common law. You don't necessarily want to ask every single client, when did you get married? What's the date of marriage, right? What was your last name on the day you got married? You can say, were you married, yes or no? And if yes pops up, then you can ask those additional questions. And when you set it through a program that has automated follow-ups, it will email your clients before your meetings to make sure to remind them to fill those things out so you're not chasing them. So I have a couple examples of ones that we use. Our first iteration was through Google Forms. So if you have Google for Business, and that's your back end for your email, then you also have access to all the Google apps for business. And our first iteration was using the Google Forms. They're pretty user-friendly, easy to build, easy to use. You can set up required questions. All the information is stored on a Google Sheet, and it's pretty easy to get at. Last I checked, there wasn't any conditional logic available. So when I first did this, I had to set up, I made a whole bunch of required questions and basically said, if something doesn't apply to you, please say NA, right? But then the client had to keep saying NA, 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 right? It's a bit much. And the forms themselves are a little bit clunkier, not quite as nice to look at. Now we're using Clio Grow for our forms. Again, building the form itself can be a little bit clunky if you need to rearrange the order of the questions. The drag and drop can be a bit difficult, but not impossible. There are required questions and follow-up questions available, and some conditional logic in that sense. And it links to your Clio Manage account. So if that client retains you, you can easily say, please move all my data from this into my Clio Manage. The client gets an email when they need to fill it out. They get another email when it's done, and you get an email as well. And you can download as a PDF, or you can access it on Clio Grow. So we use these in advance to gather all the basic data in terms of dates and names and birthdays, date of separation, so that when we sit down with the client, we can immediately start talking about their family law issues. So how do you meet with the client if you can't meet with the client? Our primary way of doing this is by Zoom, the software that we're using for this meeting. Generally speaking, I have a few video tips, and then I'll move into some Zoom specific things. As Chris said at the beginning, there will be tech failure from time to time. It's inevitable. So have a plan for what happens. If suddenly your internet goes, your client's internet goes, you lose a connection, and this applies for initial consultations and for meeting with your clients all the time, give them a number that they should call or an email that they should connect with if you get disconnected. Confirm before the meeting starts that your client is alone and that they can't be overheard, and make a note in your notes of your meeting that you've done that. Some people have suggested even asking the client to do a sweep of the room with their phone or their laptop, whatever they happen to be using, making sure that they're somewhere safe, and make sure that they are on strong Wi-Fi and private Wi-Fi. So right now we're all at home. It's probably not much of an issue. People are using their own Wi-Fi, but in the future, if they are hooked in, if they're at, in a meeting room at a library or something like that, you don't want them to be on any sort of public Wi-Fi network. Consider having as well some sort of tech agreement that you send your clients that outlines the fact that you're using this tech and how it's going to be used and what the protocols are. Set up your room as well as you can. Make sure the lighting in your room is in front of you, not behind you, or else it'll wash you out. People won't be able to see you. You can buy really cheap desktop extra lighting, like a ring light or something like that. I have a ring light set up right now that adds a whole bunch of extra light to my front. And it's basically the size of a desktop lamp. And it even holds your phone if you wanted to do some sort of live streaming with your phone as well. Test out the tech first, get a friend or somebody so that you get comfortable using it, that you know how to start and stop meetings and things like that. Make sure your background is clear and professional looking. Like, these are all things that you've been hearing probably for the last 2 weeks, right? But they're good reminders. One of the great things about Zoom when meeting with family clients is being able to do a screen share, right? So you can share your divorce mate calculations so they can see them. You can share a separation agreement so you can go through line by line and explain it to them and make edits as you go. You could even open up a Google document that you could both be typing in at the same time. So Zoom specifically, just a few features. You would have used the waiting room when you came today, and you had to wait until the host admitted you. So that's handy. You can go into your Zoom meeting and wait for the doorbell noise and then let your client in when you're ready to meet with them. But don't leave them there too long, right? There's no receptionist. There's no one there for them to talk to. They don't know what's going on. In this particular situation, there's already really high stress, right? So make sure that you are on time for that meeting and let them in as soon as possible. You can lock the room when the meeting starts so that there's no way for someone to accidentally enter by randomly guessing your room code, which I think the likelihood is low, but it can happen. And you can also turn the screen sharing off for anybody but yourself. Again, just an extra security protocol layer to make sure that if somebody accidentally gets in or your client accidentally hits a button, they're not sharing something that they don't want you to see. And then the last piece that I have just started to figure out how to do, because my initial consultations to date have always been in person, is how do I do that closing prop? So you may have something that you hand your clients at the end of a meeting, right? We like to give them a bunch of takeaway flyers. We order the booklets from Clio, the Community Legal Education Ontario. And we have various handouts that we've put together over the years that tell them everything from, you know, the list of financial disclosure they need to the steps that are involved in the separation. And how do I transfer that? So I've been doing a lot of PDFs where I email those to a client afterwards. We also have some automated emails that go out to the client after the meeting to check in the day after, the week after, things like that to maintain the connection. Oh, there's the next one. So once you've met with the client for the first time and they've decided that they want to retain you, you have the ever important retainer agreement and the retainer payment that you need to deal with. And of course, identifying the client. There's been a lot of chatter about this recently. Bylaw 7.1 of the Law Society continues to apply despite the fact that we're all working remotely. And it is perhaps even more important in a high stress environment where potentially people are using this to their advantage to commit any fraud. Remember that there is a difference between identifying your client and verifying your client's identity. Identifying your client is anytime you provide professional services. Verifying is required when you're engaging in or giving instructions with respect to receiving, paying, or transferring funds unless it is exempt. And the exemption list is under 22 sub 3. So the first question is, do you need to verify or not, right? Verifying does require face-to-face contact with the client, must be in person, except for, you know, there are exceptions for everyday work. You know, even a month ago when we were all working from our offices, there were ways that you could verify identity with an attestation from somebody on the list or a guarantor, or somebody who wasn't in Canada. There were provisions for verifying their identity. And now in our current circumstances, you can use video conference for that. It's really important that you manage the risk involved with that, possibly asking the client to send you a high resolution copy of any ID in advance of that meeting and having them show it to you on video during that video conference, and make a record of how you verified their identity and what efforts you made to follow the rules that would otherwise be in place. With respect to just identifying your client, there's no face-to-face contact required for that. That's a process of gathering information from them. Retainer agreements is something that is easy to let slide sometimes, especially when things are really high stress like they are right now. But they are a really key step, as you all know. There are, of course, like the forms, the intake forms, paper options for doing this, right? You don't have to reinvent the wheel. You can send your client a PDF in an email. They can print and sign and scan and send back to you, or they can print, or they can sign it with their finger. They can annotate on a touchpad or something like that. But there are also paperless automated options available, whether that is setting them up through something like HelloSign or Adobe Sign, where you're sending the PDFs you already use, or you move to a system like Clio Grow, where you are creating and sending and getting signed all through that online system. So this is where we use Clio Grow, and I have some screenshots of how we've done those. We have templates for all the different kinds of retainers we do. So an hourly retainer, a legal aid retainer, a flat rate retainer. We say to the system, this is the kind of retainer I want to create, and it makes it. On the left-hand side of the screen is sort of the back end. That's what we see. And we can go through that and edit it and personalize it, customize things as needed. And then the middle is what is sent to the client. and that has signature fields built into it using HelloSign, I believe is the back end for theirs. So it's emailed to the client and they click through, review, sign, and it gets sent to us. Sometimes we also use not just signature lines, but initial blocks. If there's anything that we want to make sure that they've read and understood, we say, click here. And then there's an email on the right of what we send. And retainer payments. Credit card is your friend here, whether there's a pandemic going on or not. But remember that you can't charge the fees to the client. There are costs of business that you need to absorb. And you might want to use as well email transfers if you don't already. And if you don't have an app on your phone yet for depositing checks, you can set that up too. So really the only thing we can't take at this point is cash, because we don't have that face-to-face contact with our clients. If you're taking retainer agreements or retainer payments by credit card, make sure you know where the fees are coming from. We use LawPay, and that pulls all the fees from our general account so that the full amount of the retainer goes into our trust account. I have a couple screenshots of LawPay, but I'm gonna zip through them. The client enters all their own information. You don't store any credit card information, which is really nice. And if you're using Clio, it can be linked to the email notices that you send your clients. Okay, communication with your clients from time to time throughout the file. Remembering that you have an obligation to communicate effectively with your clients, and there is commentary in the professional rules of professional conduct that say that what is effective communication will vary depending on the nature of the retainer, the needs of the client, and the need for them to make fully informed decisions. And much like the rest of the rules and bylaws, there is no escape clause for being in a pandemic, right? And if anything, our clients' needs are changing and varying greatly from day to day because of the stress that they're under. Obviously, we all use email plenty, and that is going to continue remotely, but there's some things that we use that aren't as easy to fathom using in a remote office. One is your phone, right? We use a VoIP system, and the nice thing about that is that we have apps on our cell phones that allow us to act as if it's our desktop phone, or we can grab our desktop phone from our office and bring it home and plug it in here, and it will act as if it was in the office. For that, we use Vonage, but there's lots of different VoIP providers around. If you need to use your own phone, make sure, if you want to, that you have blocked your caller ID, and that ensures that your clients and potential clients aren't getting your cell phone number if you don't want them to have it. What we learned over time is that if you are going to be calling clients from your cell phone and blocking your ID, it's really important to give them a heads up first. Tell them you're calling at such and such a time, and that your phone number will show as no caller ID, and to please pick up, because everybody tends to avoid picking up their phone if they don't know who it is, right? And you don't want to miss your client. And scheduling phone calls can also be really useful here, because if you know you're calling a client at 2:30, they know when their phone rings at 2:30 that it's going to be you. And again, it avoids your clients having to call you when maybe you don't want to give them a phone number that they're able to call into. It is really important that you have some way for potential clients to reach you on the phone, whether that's getting your voicemails sent to your cell phone or your email account and being able to call them back immediately, or having a VoIP system set up that they can call, or having a business line at your house. You know, probably from all of your experience, that if a client can't get a hold of you, they're going to go to the next lawyer on the list. And we are in a situation where, you know, business might not be as brisk as we would like. And if we want to make sure that we're continuing to get clients, we need to make sure we're answering our phones. The last tip on phones from one of my team members was that if you need to leave a voicemail for somebody and you don't want to leave them a number that they can call back, tell them when you plan to call back so that they know to answer the phone. Say it's 1:30 and I'm going to try back in 5 minutes, or I'm going to try back, you know, I'm not available for the rest of the day. I'm going to try tomorrow at 9 a.m. Right? So they can try and be available, and ask them to leave you a message indicating when you can call them to try and get rid of the phone tag. Faxes. Despite all the chatter on Twitter and otherwise about death to the fax, it's not something we're going to get rid of anytime soon. It remains one of the easiest ways to serve documents and to be served and to receive some bigger documents. And so if you don't want a fax machine in your office, whether it's your remote office or your actual office, I suggest looking into an online fax service, and you would get all of your faxes sent to you as attachments to an email. We use Vonage. We have in the past also used MyFax. Everybody in the firm gets an email when a fax has come through. If it's not for us, we can delete it. If it's for us, we can save it into our correspondence file. And likewise, everybody has capability to send faxes like they're sending an email. You put the details for the cover sheet in the body of the email. You type out the fax with an email address format, and you attach the fax as a PDF, and off it goes. And you get an email confirmation that the email was sent that you can attach to your affidavit of service. Not much to say about meetings here that I didn't already say in terms of prepping for your initial consultations. You can use Zoom, I'll say, for meeting with clients, opposing counsel, experts, more than one person. If you are meeting with more than one person, the meeting will be limited to 40 minutes unless you have a paid account. And it's only about $20 a month and worth it to set up, in my opinion, to make sure if you're having multiple people in a meeting that you don't get cut off. And it really does just cut you off. Your window will close, something pops up and says your Zoom meeting has been terminated, right? It's one thing for that to happen if you're having a big phone call with a bunch of friends or family, and it's another if you're in the middle of a mediation or a settlement discussion. If you do use Zoom and you do mediation, there are breakout rooms available too, and lots of great resources online for training for online mediation. Generally speaking, with respect to communication, I have a couple comments on both just remote work generally and in our current circumstances. So it's firstly really important to set boundaries. It's easy when you work remotely to let your workday bleed into your personal day. If you want your hours to be 9 to 5, set those boundaries for your clients, and don't allow them or you to go past that if that's not something that you want. I currently just have an alarm set on my phone for 9 a.m. and 5 p.m. It goes off every weekday to say, okay, day starts, day ends, right? Some people might even say, don't tell them you're working from home. So they all know we're working remotely, but they don't necessarily know we're working in our homes if you want to maintain some distance there. You can, if you want to work outside of hours, but don't want your clients necessarily to think they can access you at all hours, you can schedule your emails if you use Gmail to go out at a certain time. So you could spend your whole weekend writing emails to clients and schedule them all to send Monday morning at 8 a.m. So that is a really handy feature. With respect to COVID-19 specifically, managing expectations can become even more important. We're not necessarily able to work at 100% of our capacity right now. Being gentle with ourselves and with our clients is important. And also being attuned to their changing needs. So a client that previously you did a lot of emails and phone calls with might really just need face-to-face contact right now. It's becoming more and more important to have that face-to-face contact with our clients as much as we possibly can. So to try to be aware of tone in emails and phone calls and realize when it is that they need that, when you can feel them panicking or spiraling, and ask to schedule a video call so that you can connect with them, or a phone call if normally you do things by email. It's becoming even more important to show our clients empathy, to ask how they're doing, to ask if they're safe in the space that they're in, to be aware that they may need more safety planning than they needed before they were in isolation, to anticipate some of what their needs might be, right? Think of those questions that you've heard 10 times in the past 2 weeks. You're going to hear them 100 more times as the situation goes on. And is there some way that you can proactively communicate the answers to those questions to your clients, right? Could you send a large email blast or something like that? We do have as part of this, just a remote work message that's on our autoresponders right now, and that we sent out to all of our clients when this entire situation began and we began working from home, just to, again, set some expectation, to tell the clients what's going on so that they know that they're heard, so that they know that we're working, but also so that they know that we might need a little bit of patience. We also plan on using the same thing. We used MailChimp to send out some regular updates as we get more information about how the courts are running and things like that. This is the question that everybody had about signing documents. My proviso to start is that I have been doing remote work in terms of signing my own letters and things like that, using technology for several years, but getting agreements signed and getting affidavits signed is something that is new to all of us. I'm no more an expert in this than the next person, but I have started to gather some information that I hope you will find helpful. The first is just your signature on things when you're signing letters and things like that, right? You could print and scan, you can use electronic signatures, you can sign on your touch screen, right? Affidavits are the tricky thing. Physical presence is required. And again, this is in the current circumstances, we're allowed to get a little creative with this, but we are not generally allowed to sign affidavits without the person being in front of us. You might choose to send your client a hard copy to sign and send back to you that you then sign, or you might use a DocuSign or HelloSign type thing here. For both affidavits and agreements, the thing I would say is really super important is making sure that affidavit or agreement is perfect before it is sent to be sent to them to be signed. You may be used to writing an affidavit with your client in your office, finalizing things, adding details and things like that, but you won't be able to do that the same way. So maybe do a Zoom call with them, do a screen share, make sure it is perfect before it is sent to them. And I have an example of some wording that somebody shared online for what you might consider putting in the jurat. I don't know if this is perfect, but it's something I would consider using, which details the fact that it was sworn over video conference. In our family law forms, I don't think you could personalize the jurat. So you might not be able to do something like this, but maybe put a note or something like that. In the given circumstances, I think everyone's well aware that this is happening. You're also able to file with the court for an urgent motion unsworn affidavits as long as your client or whomever swore the affidavit is available during that teleconference to speak to the judge. And then agreements are the other piece that need to get signed, and we're starting to see more of these. We all know a domestic contract has to be signed, dated, and witnessed, right? In all circumstances, you could consider clients signing in counterparts. So in a situation where you can meet with them or they have a witness who can meet with them, you sign it on one version and opposing counsel signs it on another version, right? In the current circumstances, you could consider them signing it on a video conference, the same way you would do an affidavit. You could do online signatures where they're signing on their screen or their touchpad. Maybe you have a situation where you have an office you are still safely able to go to and there's a window, and it may feel funny or strange, but having them sign that through the window where you can see them, right? It's getting creative, right? And then a few notes on getting paid. We already talked a bit about credit cards for retainer payments. Nowadays, you may be wanting more and more to set up payment plans. You may have clients who owe you money from previous files and they're hitting hard times financially. Look into whether your credit card offers automated payments where you can agree that it's going to be charged a certain amount every first of the month or something like that to secure the payments happening. You can transfer money out of your trust account using your bank account online transfers. That's always been permissible. You need to look at the Law Society rules. There's something called Form 9A that details the transfer, why money is being moved out, who's requesting it, when, where it's going, and who is making the actual transfer. So making sure, again, that you're following the Law Society rules. I'm running out of time, so we're going to do some quick stuff on how do you work with your team, right? Tracking the status of the file, knowing where things are, right? If you're a sole practitioner, it's all in your brain. You can track it all. Maybe you have some sort of online form, a spreadsheet, something like that. But many of us are working in teams, right? A status sheet is a really great idea, whether you work remotely, whether you work with a team or on your own. And it's becoming more and more important when we're in a situation where any of us could become ill rather quickly and be unable to work. This is part of your contingency plan as well as part of your practice management from day to day. So we track on a shared Google Sheet with every lawyer having their own tab, what the file name is, who the opposing counsel is, the current status of the file, what's coming up next, what we're waiting on, or if we're working on it, what the important dates are, and things like that, so that we know where everyone else's work is. And if something happens to any of us in any given circumstance, we're relatively easily able to pick up our colleagues' work, know where things stand, and be able to transition seamlessly to a new lawyer if somebody gets sick or something like that happens. The important thing is making sure someone knows where it is, that it's easy to find, it's obviously named, that if you're a solo, that you've appointed somebody who can take over, who you've made aware of all of these things, and that you've signed a power of attorney for your practice if you haven't already. And this is an example of an online status form. If you're familiar with Kanban or Kanban boards, Trello is an online way that you can do those. Connecting with your team becomes even more difficult when not only are you working remotely, but there's not a situation in which you can drop into the office and say hi, right? As well, if you have people working for you, students or legal assistants or things like that, you have an obligation under the rules to supervise their work, right? And much like the other rules, that doesn't go away. So how do you stay connected? Okay. We use video right now. We're doing Zoom meetings every day or every second day where everyone pops on, right? And it's important to have a mix of productive conversation where you're saying, where are our files? What's going on? Who needs help? What are we troubleshooting? What's going on? Things like that, as well as just hangout time, right? When you work in an office, there's that moment in the day where everyone just sort of lands in the kitchen and making coffee and grabbing their lunch and saying, hey, and what's going on. And some of our Zoom call is just that, right? It's saying hi, it's talking about our weekends, it's casual hangout, fun time for all of us, right? We also use Google Hangouts for its instant messenger feature because it's right in our email. And some people also like using Slack. We also need to connect with people outside of our offices, right? We need to keep building our networks. We need to keep building our referral sources. We need to keep having business coming in the door, and we need to keep serving our clients. If you're not already on social media, I imagine most of you are, but Twitter is a great place, especially now, to connect with people, as is Facebook. There is a Facebook group that another lawyer started just called Ontario Family Lawyers, where people have been sharing all the decisions they've been getting about whether a matter is urgent and what the different updates have been from their local practice area. And that resource has been invaluable as we all are, figuring out this new way to do things. And you might also want to use this opportunity to get on top of your networking or your social networking and use something like Hootsuite to set up some automated messages to go out to your social networks and to build up your online presence. Virtual networking, just a word here, you can do Zoom calls with them too, right? And when we're out of a situation where COVID-19 is in play, maybe you can send them a gift card before or after the meeting, right? Send them a quick Starbucks card in the mail saying, I'm looking forward to having coffee with you next week, right? Making sure that you're maintaining those connections, even though we can't do lunch, we can't do coffee, we can still connect to each other face to face. As well, super important to keep asking your clients for feedback. It is really easy in a remote situation to lose connection with your clients. When you're always calling, when you're always on the phone, when it's always email, you can start to lose a personal connection with them and start to miss out on asking them how they're doing, right? So make sure that you're asking them, you know, how has my service been? Tying questions for a client survey to what your goals are. Maybe looking into something like your Net Promoter Score, tracking other things like that. If you have any downtime in your practice right now or in the future due to this pandemic, using it as an opportunity to build up these systems. And then the last little tech tip is not really a remote tech tip. We use it all the time, but helps making remote work and cloud-based work even easier, which is using a tool like Zapier to connect our tools together. So I mentioned that our contact form, they get an automated email. And we use Acuity and MailChimp and Clio. We get all those things to talk to each other in the back end by using Zapier. Yeah. And these are just, I have a couple screenshots with how you do it, but essentially you tell it when something happens over here, I want something else to happen somewhere else. And it actually is quite easy to set up, pretty intuitive stuff. And then my last plug is making sure that you're taking breaks, whether it's remote work or it is our current situation, making sure that you're taking care of yourself, just like we set boundaries from day to day and setting our business hours, making sure that you're not always working, right? The Easter long weekend is coming up, right? You normally would have closed on Friday and Monday for a long weekend. So do that, right? Or yes, we cannot, travel to the palm tree places that were on my previous slide. It might be a staycation, but you can take a day off. You can take a week off. You can take care of yourself still in that way. Making sure that you're sending some sort of out of office message that indicates you're not there. You're away from the office. You're not going to be able to get back to them. What they can do if they need to hear from somebody more immediately, and using it perhaps as a value add opportunity. We always provide the booking link for new clients and for existing clients. So if you'd like to connect with me upon my return, feel free to book a meeting using these links. We sometimes will provide links to blog posts, or you could, if you have a newsletter, direct them to sign up for it or share customer reviews or something like that. So it's not just an opportunity to say, I'm not here. It's an opportunity to say, in a warm and empathetic way, I'm not available to help you, but here are some things that might help you while I'm not here, and I look forward to talking to you when I get back. And that is, oh, can you see my pretty question slide? There's my pretty question slide.
Jennifer, that was fantastic. A couple of questions. First, will the presentation be made available?
I believe Chris is you recorded it, right? And you're posting it on the Ryerson site.
Yep.
So when you view it on the Ryerson site, it'll look just like as if you were watching it today. So you can listen to my charming voice again, and all the slides will be there, and you'll be able to pause it on things and see. I know I went through some of the text heavy things a little more quickly. Fantastic.
A couple of questions about online signatures and verifying identification. So when we're doing if we're doing a Zoom or a video chat and you have to verify somebody's ID and they flash their license or some other form of identification, I mean, how do you know it's real?
Yeah, and that is a good question. Having them hold it up, having them to show you different sides, right? Having them send you a copy, but nothing really replaces holding it in your hands. I did see recently and tried to access it for this presentation, but it wasn't working. There was a way to type in somebody's driver's license number, I think, and verify that it's a real driver's license. And I believe they've made that service free in the current circumstances.
Oh, great.
Yeah.
Can you just go over again briefly the online signature piece? Somebody was asking about how do you do that?
Yeah, so there's applications like DocuSign or Adobe Sign, where basically what you're doing is sending your client the equivalent to a PDF, and it has fields in it that are interactive, and it asks them to sign it. And it asks them at the beginning to verify that they consent to using an electronic signature. So it guides them through, they click through, it tells them all the places they need to initial or to sign, right? So that's a really good option. Another is having, if you send them a PDF and they have an iPhone or something with a touch screen, they can annotate that PDF, right? We all have that ability now with the fancy phones where they sort of zoom in on where their signature line is, they can sign it and send it back to you, right? And then there's the good old-fashioned print it, sign it, scan it back to me. If you need to witness, I'd say it's, they're signing, they have a hard copy, they hold it up to the screen, here I am, here's my signature on the page, and then they send you the hard copy.
So you were talking about Clio Grow. Does that work the same as DocuSign was the question?
The retainer agreement piece, I think, does. Okay. Yeah, so it sends my client an email, says, please click this link to sign the retainer agreement. And it gets sent to them and it guides them through clicking, and it records when they signed it, I think their IP address, things like that.
And then there's, it's a tough question. Somebody working for a legal clinic and a number of their clients don't have technology, or they require interpretation services. Is there any thought about how we're going to negotiate this world in the near future?
That is a really good question. It is not one I've put a great deal of thought to yet, because my clients, the ones that I'm working with right now, don't have that situation, and we haven't been in it long enough that that's developed. If at the very least, one can hope they have access to a phone and they can still talk to you that way, right? And you might need to do, like when it comes to getting documents done, some sort of drop off, send things by courier to them, right? We don't, just because we're in this situation, I think our default is to be like, what's the fancy tech way to do this, right? I'm now remote, so everything needs to be done online, right? But you can still, get a good printer for your home office, print things off, drop them to your client, drop them in their mailbox, let them know that they're there, arrange a secure mailbox where they can drop things off to you, maybe sending things through their worker, right? There are ways to maintain social distancing, and if absolutely necessary, meeting with a client with appropriate health precautions, but who knows what those are from day to day, right? So my stance is not meeting with clients right now. That feels like the safest thing for me. But for you and your practice, you might need to find other ways to make it work. So making sure you're aware of the most recent recommendations and following those.
That's fantastic. And just while you were answering that, one of our viewers suggested that for multilingual meetings, you can use the interpretation services of a third-party app.
Oh yeah, absolutely.
Kudaway,
Yes.
Kudaway.com.
Yeah, there are, or, if they have Zoom, you can get them and the translator or interpreter on Zoom with you, right? That's assuming the tech is available. And yeah, there are some cool tools that will do that for you.
And last question was about retainers. Mm-hmm. I noticed the full text of that attached agreement PDF is also in the body of the email sending it to the client. Is that the best practice?
The body you saw, the email that goes to the client, is not the retainer agreement. It's attached. What the email says is, thank you for selecting us. you are going to need to do the following 3 things. You're going to need to pay the invoice that you get. You're going to need to review our office policies and let us know if you have questions. And you're going to need to click here to sign your retainer agreement. And then they get taken to that PDF that was in the middle. And then they are emailed a full copy of that PDF once they've signed it.
And I know you touched on this earlier in the presentation. I just didn't want to leave an incomplete impression. When you spoke about the possibility of using the courier, you were not necessarily thinking that you're giving your home address to the client. The courier could deliver it to somewhere else.
Right, yeah.
Exactly.
You could ask like if you're comfortable giving the courier your home address, right, you can ask them to go pick it up at the client's and bring it to you, right? We do those sort of backwards couriers all the time.
That's great.
Something like that.
Well, again, Jennifer, thank you so much. This was a fantastic end-to-end. There's a lot of meat and material there and will be very, very helpful, I know, as is evidenced by the numbers on and the attention. So thank you again. All the best.
You're welcome to reach out to me if you have questions. I'm on Twitter. My handle was on the bottom of all the slides. It is a lot of information and it's a lot to take in. Do one thing at a time, right? Nobody's a hero. Everybody's exhausted right now. And do what you can and let me know if I can help.
Thank you very much. You already have.
My pleasure.
Take care.
I will end I don't have the buttons. I've lost them, Hirsch. There they are. All right. So my screen share should be out and we're ready for Ian.
Thanks, Jennifer.
Bye, everybody.
Well,
thank you, everybody. Now I'm going to turn it back over to Hirsch. And Hirsch, you're going to be introducing our next guest.
Yeah, so it's definitely a tough one to follow. Jennifer did fantastic. Thanks again, Jennifer. But we do have another great expert in Ian Hull, who has joined us today. He is the co-founder of Hull & Hull, and he co-founded it back in 1998 with his father, Rodney. He is a certified specialist in estate and trust law and civil litigation. He has written 4 books, including the seminal Probate Practice, now in its 4th edition, and is a recipient of numerous awards, including several Lexpert ranked, and just this year recognized by Best Lawyers. So I'd like to welcome Ian to the stage.
Hi, Hirsch, it's Ian. Working?
Yeah, it's perfect. You just
Great.
grab the screen.
All right. Perfect. Well, welcome everyone. And I echo the comments of Chris and Hirsch on Jennifer's seminar. I watched most of it to get the tips and traps exposure that she gave was fantastic. I'm going to try to approach it a little differently. And to do that, I am going to, sorry, get my video going. To do that, I am going to start on the macro level and then work on a micro level. And when I say that is I want to talk about some more global issues in relation to managing a file, a civil litigation file in this new world. And also I've got some checklists and some process suggestions that might help as we go through. So I guess right from the start, it seems to me that we should try to look at, I'm just going to share my screen here with a couple of easy resources. And the only reason why I've got it going to my page is because I know where they're found. So what we've done is in this environment, we have put up a special link, COVID-19 Wills and Estate Planning Resources. And that's taking us to what we just sort of are identifying as urgent blogs. We blog, as Jennifer said, marketing is important to keep going and all of these things during this period, but always during your practice. And we blog daily. But what we've tried to do is collect together some of the more urgent ones. For example, we did a blog about courts closing, but most importantly, of course, that'll take you to the actual blog, the actual notice of the Superior Court as of March 15. That kind of availability is there for the resources. While it's not a litigation issue, you've got issues relating to the possibilities of specific issues relating to wills and estates. So those are just some resources that I recommend in the sense that it's easy to get to and can give us some opportunity to get some quick answers to what are, I would describe, some the urgent issues right now, or some of the urgent issues. I now just want to share a little bit about some other resources that I want to walk through, and I'm going to share my screen relating to a couple of innovative techniques that have started to develop in the last couple of weeks. The Family Law Bar and the States Bar now have created a sorry, I'm not finding it easily, so I'm just going to have created a wills and estates arbitration tool. So what this is doing is, and this is completely something that I'll get in a minute, is something that gives the profession an opportunity to operate while the courts are closed. And what the Family Law Bar started this, and the Estates Bar is starting to circulate it as well. It's setting up an arbitration agreement where the parties enter into and agree to hire an arbitrator who will deal with short-term issues, so to speak, issues that, for example, undertakings and refusals or something like that, one-off issues that the parties will agree that they will be bound by the decision of the arbitrator. And what we've done in the Estates Bar and the Family Law Bar as well is we're starting to collect together people who are prepared to arbitrate these cases on a summary basis, in a sense, and on a fixed fee basis. I think we're going to put the hourly rate for the arbitrator at $250 an hour. So it's not expected that this is going to be an onerous thing for senior counsel to take on the role, but it allows people to start to bring together their practice to move it along in what is a situation of pretty dire circumstances. Because while we hear that the courts might open up a little bit more by April 6th in terms of access, the reality is they're going to be backed up significantly. And so this is just a tool, and I'll pull it up shortly and circulate it. It's just another tool that allows the litigants to consider operating through what would be described as interlocutory issues, while at the same time allowing for example, if you need a court order in the area of estates, we'll come to it, but you need an estate trustee during litigation and a will challenge. Well, that's a court-ordered appointment. Well, sometimes it's a fight over who the estate trustee during litigation is. And so if we could enter into this arbitration agreement, make submissions in front of an arbitrator, have the arbitrator make a decision, the parties would be, the agreement would provide that the parties would agree that that order would be sanctioned by the court, and you just do an in-writing motion and you get your appointment. So that's just an illustration of how you could move things along. It's important in the estates area because you need, and not just the estates area, through civil litigation, sometimes you need third-party supported orders. What I mean is, if I'm going to ask for the production of a lawyer's file and a will challenge, or if I'm going to ask for production of the medical records, which is truthfully going to be very hard to do in the hospitals right now because they're obviously tied up with more important things, but a lawyer's file is an easy illustration. Well, you get a court order on consent, essentially, because once it's been adjudicated, and then you send it in for writing. And I know in Toronto anyway, the Toronto list, we're mailing in these orders, and the court is dealing with it as a basket. So that's just an illustration of a unique tool that's out there that might be of some use in the right circumstances. That's on a macro level to avoid log jams in the moving forward of files from a legal and substantive standpoint. We have, in terms of just day-to-day contact, it's, I just want to call up my frequently asked questions. I'll get it in a second. The frequently asked questions from the law study they published in terms of the affidavit. We already heard from Jennifer the process, but the law study has on its link the steps you take in terms of verifying the new terms for verification of clients and the remote affidavit of service requirements. All right, so I did want to echo a couple of small things that Jennifer referred to in terms of social media, because it's not just marketing, it's also getting yourself access to groups. I belong to a few groups in the estates area and LinkedIn, and they've been a tremendous source. For example, this morning, 25 of us were on the phone with the Attorney General and he called a Zoom call in because brought in a bunch of us from the profession to give some input on changes to the legislation regarding execution of wills. And he wanted this was the most efficient way to do it. Well, that group, of course, once the change is made, we all know about it. We're going to post on social media and make sure everybody in the profession knows about it as well once the change is made, if it's made. So it's also an important resource, not just a marketing resource, it's an important resource. So watching for changes in the law is a great, another good reason why to do the social media. On the driver's license searches, again, I think I can find it in a second. As I go through this, I'm going to be pulling out a lot of these. It is a free service right now, and as Jennifer said, it won't tell you the name, but it'll tell you if the driver's license is valid. So an important tool. Okay, so now I'm just going to start with the process of walking through the process of walking through a lawsuit in this environment. And what I'd like to do is pause, and of course, Chris, if there's any questions as we go along, I'm more than happy to deal with them as well if it's easier. But don't be afraid to jump in and tell me if there's some questions that are coming in. All right, I'm just going to share my screen with a tool that I use, and this is a tool that was created pre-COVID-19 for the purposes of working outside of the office with my associates and with my clerks to make sure that a litigation file moves along. Now, I started this discussion with a resource that is going to be, first of all, the expansion of the courts, and second of all, this arbitration agreement resource as options. But that's on the substantive piece. This is the practical piece. Now, I don't for a minute suggest that this is the only way to do something, but what I was finding was it was difficult for me if I was remote, or if my associates or clerks were remote, to stay on top of each of the steps. So I created this. It's simply a Word document. And I will do the caveat at the beginning that I could certainly make this available. I just have to make a few edits probably. But the caveat is that I have done a lot of writing in the area with LexisNexis. And so I actually link to a lot of their stuff because I have the service. I wouldn't expect everybody to necessarily link to whatever service you're using. Okay, let's just make sure I haven't made any mistakes so far. Okay. That's fine. Good. All right. So I want to stay away from some of the detail that Jennifer gave because although there'll be some overlap, it really was fantastic, and it dealt with true client management and file management issues. For example, there was a reference she called up on the screen, the intake questionnaire. Well, I'm going to go through my presentation a little differently, only in the sense that this is going to be more focused on the steps as opposed to the granular piece. So for example, my opening file, I've got my initial contact, whether it's a clerk or it's me, and that I have my own intake questionnaire. So people can use the intake questionnaire as they see fit. I obviously do my conflict search and so on. I have a trick in the trade, but I've been doing this for many years. Doing this is that I'm in the referral business, and I think most litigators are in the referral business. I will almost always, and if I haven't, it's because I've mistakenly done it, not because I meant to do it. Is I will send a thank you card, and I use my handwriting, which some would say is impossible to read, but it's personal, not an email, but a thank you card. To the referring lawyer. I do this at the outset of the file, and I do it at the end of the file when I'm closing the file, so that the lawyer knows what's come in from whom and when, so that if you're in litigation practice and you're getting referrals from lawyers from the other areas, the last thing you want to do, I always say, you don't want to bounce back. You want to get it off your desk and get it on. If I get a tax problem come in, I want to make sure I've referred it out. I want to make sure it's landed. I want to feel better once it's landed. I don't want to hear about it again, in the sense that I can't help anymore. Maybe I have to give a different choice of a lawyer, but the point is that I've made that contact to the lawyer. So I make sure I know who the referring source is, and I put in a little Starbucks card as well, or Tim Hortons or whatever I've got on my desk. But it's just a nice step for the referring lawyer, but it also helps me make sure that I keep a personalized contact. The file opening sheet, again, these are all documents that are internal. Probably everybody has them, the retainer agreement itself. And I'll just pause there with the retainer agreement. Joint retainers, of course, are a much more prevalent tool in the estates area, but they obviously exist in all litigation. The fact is that I can often get a situation where I'll have 2 or 3 brothers and sisters come to see me who are representing the challenge to the will, or I have 2 executors. So I have, of course, carefully crafted my joint retainer agreement and my retainer agreement. Now, here again, this is a Word document, not rocket science. I've got a link to the retainer agreement for joint clients, and I've got retainer agreement itself there. I've got a pre-populated standardized document there, which I'll use. I have in our area, in lots of areas, you might have contingency agreements. You might have nil retainers, where in the estates area, sometimes there are circumstances where you don't ask for any money up because there's going to be money at the back end. Those tweaks, well, if you keep them all, as I've done here, just created footnotes, they're there, they're boom, they're populated by my clerk. I look at them, they go out. All of this is done remotely without any fanfare and without a whole lot of keystrokes. One of the things that I learned long ago, my brother went to high school where they taught him to type in grade 9, and I never taught me, and I always regretted it, but I can't type very well. So I am a guy that doesn't really like typing. And so anybody that can help me do less keystrokes is okay by me. But in the litigation area, of course, you also want to be careful because typos can be a curse. And so the least amount of typing for me to do was good, but also it doesn't allow for mistakes. Some people are great at typing, so it may be not so important, but I just tried to create all of the scenarios for retainer agreements right in my list. Here in the initial meetings with clients and first steps, again, I've got the whole thing. I've got a remote client. What I haven't done yet is put in the new rules that the Law Society's created for remote verification, but that'll be done. So once I've done that, I will, the next steps are steps for which most of us will do intuitively, but again, I'm trying to work remotely and obviously working totally remotely now. And I want to make sure every step is taken. So I have this old school, check the box. I have, to the extent that these are all internal sort of steps that I have here, they exist. And the initial meeting, the initial strategy meeting I have, and then the important considerations after the initial meeting. For example, for me, considering limitation issues, children's lawyers issues, trust issues, ILA. This has been drafted. This checklist is for will challenges, and I have a checklist for all of the subject areas that I practice in. And I'm lucky, I guess, in a way, because I don't have this volume of subject areas as some civil litigators would have, but I will have a, typically I have a, I've got removal litigation, I've got power of attorney litigation, lost wills litigations, and so forth. So you can see that what I've done is actually created a procedure manual for each one of the subject areas. The fact is that you can repeat a lot of the content. So if there's an area where you're doing real estate litigation and commercial litigation, I mean, construction litigation, and there's slight nuances, you can create your own document as you see fit.
Sorry to interrupt you. The screen share was not up.
Yeah, I know. And it's because I didn't, sorry, Chris, I was going to call something up and then I saw it. I didn't realize it wasn't going to help. So I'm going to put it back up now. Thanks, Chris. So we're going back into the screen share. I was going to share something else, but wasn't going to help. So I'm going to just stay back with my document. Okay, so staying with the will challenge procedure. So I'm at what are pretty well, preliminary steps, but all of which have nuances that create, it's not just substantive law nuances, there are client management nuances, and I tried to create this document to consider both the substantive and the file management and the client management. And so you can see that I actually put it at page 4 at the top here. I've got timing in some of these. Within 24 hours of the initial meeting, I've got to file a notice of change of solicitors or a lawyer, and notice of objection if it's a will challenge if necessary. I've got links to the documents right below, and you'll see at the bottom I've got Lexis Practice Advisory. That's just, as I said to you earlier, that's a document, that's a product that I use, but you can create all of these in Word. So none of this needs to be tied to it. It's just, I created those documents in Lexis, so I know they're right. They're the form that I want, and so I just use them. The timing, I think, is so crucial because and Jennifer touched on it too, client service is so important. And I find in the litigation practice, and I'm sure Jennifer would have in her practice too, is the feedback is very difficult to get. Direct feedback, meaningful feedback. You're either stuck with a system of the courts are bogging you down, or the other side won't reply, or you've got all sorts of reasons why something may not be moving along that aren't within your powers. I always look at it as this, and I created this document with this in mind, is that timing is just as important for the moving of the file along. Nobody wants a problem to last. They come to see you, some are vigorous, they want to litigate, they're all set to litigate, but you know, we all know within 6 months or whatever the time period is with litigation, clients lose their steam. And so, you know, I always thought, I've been doing this now almost 30 years, the greatest turn of event for access to justice and file management was mandatory mediation from our practice area in the estates area, because it forces the file to move along and globally. And so we have no choice, but we have to get to mediation at some point. And you know, I used to say that you know, a file, when clients came in, you got to look to about 18 months before we can really give you much good feedback in terms of how far along, meaningfully along in the file. I think now it's 9 months, and I think in large part it's because of mediation. We'll talk about how we get to mediation and when in a few minutes, but time of getting to mediation is so crucial to feed every file. And it's not because I'm afraid to go to trial. I've got lots of trials. I love going to trial. You know, if I have to, I'm going to go to trial. It's that mediation is really the only practical way to resolve things. I act for people mostly. You'll see I act for LawPro, so I have some LawPro unique tools in this, but I act for people, and people do not have the stomach or the resources to go on endlessly. So early on in the file management, again, this is active on my corporate commercial litigation as well, if it's an oppression remedy or something like that, but also in estate matters, is the corporate summary sheet and a checklist. And I've created a checklist and summary sheet just so that I've got it. And sometimes I just want it on a one-pager, so it's available to me, so I can get the corporate chart out, or I can craft the details of the case. I often will put together a short form chronology, sort of the top 20 key events, not long. I want to have a big picture. For this case, it's a wills case. I'll have like, when were the wills done? When's the date of death? A couple of other key things. When did she see the doctor? Or those kinds of things. But I don't want to keep it more than 20 or so entries. I want to be able to quickly one-page look at it. Then I can also create a long form chronology, and I work that up a little later in my sheet. But as you see at number 3, I have a summary sheet that I keep to 1 page, and it's a summary sheet that I can look at 1 page, identifies the key issues and the key chronology. There I'd have like the key issues. It's a will challenge, it's an unjust enrichment claim. These are the dates of the wills, and here's the amount involved. But that's just my 1 pager. Again, Clio and some of these other online services provide these sorts of resources that I've just had to create them myself in Word and link it. So it's not that complicated. The corporate summaries, again, someone's always got a corporate chart they can send me. I scan it in and away I go. Oh, scanning it in, just as a little suggestion, there's a really cool tool that I use now off-site, and some of you may know it or may not, but you can use your iPhone to actually scan your documents. So I don't know what this is. Oh yeah, this is, I guess, an initial email. That's not what I'm looking for, but there's when I send if I could find the site, I will, I don't know why that came up. Maybe I saved it wrong this weekend. It's an iPhone. You can you go into notes, And I think I've just screwed up where I've saved it. But you just go into notes and you follow the steps, and it's really quite easy. Here it is here. Oh, I found it. My system worked. All right, so here's a tool that how to scan a document. You're going into notes, you're hitting the plus button, you're scanning the document itself, then you take the marking of it, you save it, and you can send it. So it's a scanned document, and it actually lets you restrict around the photo itself, so you don't have the table you've scanned on as well. It actually looks like a scanned document. So it's an app that right within an iPhone, which I thought was a cool top tool, and I'll send that around with the materials. So from that standpoint anyway, at the early stage of my retainer, I want to get as much information in once. And I have a rule, when I draw wills, I do the same thing, but when I'm in litigation, I want to put something in once. And I find that I've got a tool that I use. This is just one tool that I have. It's that I want to get the materials in once, and then I want to, that way less typos, less problems, and then I've got the assets to deal with as I go along, and the information. So on my intake, I've got a tool that I craft the family tree. For example, in my work, I see a lot of family trees, so that has helped me a lot. Then I'll put in the assets, and I'll literally have all of the assets in with detail, setting out what the assets are, and that really helps me at the mediation stage, because at mediation, I don't have to sit there and say, okay, what are we doing? What was that vehicle was worth $6,000, right? Okay, well, let's give them the vehicle and let's keep the bank account, that sort of thing. So I've got this in there, and I'll update it, and I've always got the information available. This allows me to get to what the beneficiaries' entitlements are. So for example, here, this is a summary chart that comes out of my app. But again, these are just tools that you know, once you're in mediation or you're in a high stress negotiation, you don't want to be looking for this or guessing wrong on your information. So if I put in all the assets properly, then I've got the gross estate, I've got the debts and liabilities are estimated at, this is estimated, most of it, it's not calculated to the dollar. I got to make sure if there's an initial gift, sometimes there's already a gift going to the church or something, I got to make sure is calculated in, and then I've got the balance of the estate. Well, this tool itself is obviously drafted more for use in estate matters, but it still gives us an opportunity to get the documentation get the information in once, get it in right, and not have to worry about looking for it and finding it in high stress negotiations, like a negotiation and a mediation or something of that nature. All right, so back to the will challenge procedure manual itself. It's I find these initial stages are, and sometimes it's a bit time consuming, but these initial stages are important to have crafted these steps, because, and I actually have got it down to where I've got my clerks doing a lot of this. And sometimes I'll get an Article student doing it too. It's great experience for them to see a file start to finish. All right, so now that I've got the file information in and I've got it prepared, I've got timing, and you'll see back here, I've already got my initial reporting letter. You see, you've got the strategy meeting, important consideration, urgent steps, because sometimes if there's injunctive relief or so on. But then I've got the file information in there, and then I start to look at how am I going to move the file along. So the file review, of course, number 4 is every 30 days minimum is my file reviewed. And in that regard, I do what I call a completion report. Just like Jennifer was saying, I have just again a Word document spreadsheet talking about the most recent steps, the name of the file. I always have the limitation periods that may or may not apply, the steps that are current, and then the tasks to be done. And I get my associates and I and my clerk, we do those every 2 weeks. The final column on my completion reports, though, is how much WIP do we have and how much AR do we have? Because that, of course, drives much of the considerations, truthfully, when you're trying to file manage. But in this case here, you can see that I've put in strict timelines here. I've got 30 days, every day, at least 30 days I'm looking at a file, and then that's minimum. My completion reports pick that up in any event. And then I've got other steps, again, client contact. So I have a rule at our office: emails and telephone calls must be responded to within 24 hours. It can be as simple as, I'm going to get to this, I'm going to get back to you, I want to consider it. but everything has to be circled around to the client within 24 hours. I also have another rule that everything that comes in and out of the office goes to the client. And those are rules that are probably pretty consistent. But the thing is here, again, I've got my clerk watching this, the timing of these things to making sure it happens. Counting and dockets are, it's an internal system that I have, which is not going to be all that relevant to anyone else. But you'll see here at the bottom, I've got LawPro. Well, I've been fortunate enough to be on LawPro's list to do their work for years, and I don't, they have very particular systems. And so as a consequence of that, I built them into this system so that the clerks and the associates and the partners all know what unique steps are going to have to be done. We have a procedures that LawPro gives you specifically, and you'll see I've even footnoted it, LawPro file procedures, and away we go. Now, in a lawsuit for will challenges, you've got two ways you can proceed with a will challenge. You can proceed by way of application for directions, or you can proceed by way of statement of claim. Either way, it doesn't matter to me. Most of the time it's done by application. So that just happens to be where I like to use it. And sometimes, truthfully, I use it because I really like the Rule 39 rights that you have for non-party witnesses under an application. And that's typically one of the reasons why, but it doesn't matter. So you're going to start a lawsuit. You got to do this, and we're working remotely. We got to start by notice of application, or we're going to do it by statement, by statement of claim. Again, here, what I've done is I've pre-populated core topic areas. This one is easy to, obviously it's a will challenge. A notice of application for directions for a will challenge, I've got pre-populated, and I've got a precedents. I've got a couple of precedents in there you can see in terms of that. Now, preparation of that is lawyers' work typically, but it's can at least get started by one of my clerks or an articling student or associate, whatever, so that I can start to work in it. You'll see here will challenges KM index in the middle of the page. About 25 years ago, we started, and many of us have this sort of an informal, we call it knowledge management system. Basically, it's a giant precedent system. It's on a platform that's a bit cumbersome because the software hasn't been updated as well as it could have been. And but all the complaints aside, it's a giant resource. So it's keyword index search, and it's there for anyone to go to if they need to. Other claims and proceedings is important for the nature of the claims. So in this case, there are sub-claims within a will challenge that I would consider, like in any other commercial litigation. If you're going to go for an oppression remedy, you might go for unjust enrichment as well. All of the different tools that are available, you might have to include in solicitor's negligence claims. Again, I'm trying to pre-populate some of those with a link. The preparation of the materials, of course, is a big part of the lawyer's work, but I also want to get draft orders done, factums, get the confirmation forms in once the courts get going in. And my draft order is really in the states area for a will challenge like this, typically the area of most negotiation. And that comes back to my earlier comment. If I know the assets and I can go to a document that gets me the assets quickly with precision, even the net assets, it's going to help me if I'm in a negotiation in the courtroom and we're outside the door and we're talking about a term to the order for directions that may or may not affect me that much. It may not have that big of a financial impact. Nice to know precisely what the assets are. And sometimes it's hard to keep all of that in your head. So that's why I use my app to just have that material there and it's ready to go. And it's an online app on the cloud, easy to use. All right, so again, some of this stuff is pretty particular to getting an order for directions, but we, in these orders for directions, we're asking for third-party orders from from hospitals, doctors, lawyers, and financial institutions. So I try to set up a system where my clerk is tracking that down. It's no different than creating your own affidavit of documents in a general litigation matter. Expert opinion, again, I've got my specific rules in there, watching the these are just little glitches that have occurred over the years in regard to that. And then we turn to the affidavit documents. Now the affidavit documents, again, I use a tool. Some people use summation. Our firm has never been in the big enough document cases to get into those giant tools. There's a program called CaseMap. Not that I'm a salesperson for LexisNexis, but I just happen to use it as well. And it is a terrific tool, and it has brought great organization to complex documents. In my cases, it's got a great tracking system. But again, I'm not trying to sell the document. I'm just saying that a document management system within itself can be fantastic. Now, I have a DMS internal system, which I won't get into, but it's a saving, as most of us have offsite saving ability access through. We use Horizons right now. It just seems to be the most effective offsite, but Go to My PC is an excellent one as well. But I'm talking here about creating a proper affidavit documents, and the case map is a terrific tool. It's just a giant chronology in my view that is, you can link the documents, you can track the documents, you can sort them in different ways. It's a really effective tool, and it's not, it doesn't have the same infrastructure needed as summation does, and it's speaking pricing wise, it's competitive and for my purposes anyway, well worth it. Mediation, again, here I am. If you look at my list here, all I'm trying to do is create steps that aren't missed, but at the same time aren't being done by me or can be done by others if we need to. So for example here, preparation and mediation brief, a first draft. We've got pre-populated mediation briefs for a will challenge. Now again, I get that that's not going to always be the case, but if you do a lot of oppression remedy work or a lot of real estate work or a lot of foreclosure work, you find if you spend the time, and as an aside, I've built this up myself over the years by using very smart summer students to help me hone this, because you don't need to have deep substantive knowledge to know what piece of the puzzles to put into these, and had some great success with some students who are in law school, summer students. So again, the pricing model can be more less dramatic and for you, and you're creating your own system that allows you right now. And here I am in this environment, I can make sure that I'm tracking every one of the files I have actively remotely by ensuring that these lists are being followed. I have this on my DMS system, so you can link to everything. Right now on the screen save, I'm obviously not going to link to everything, but I can go into my DMS, I can save it as a document, I can have it linking, and then I can keep track of things. If I say, geez, I'm wondering what's happening with that expert report on that file, I can go right into it offsite and find out what's going on, or send a note to the associate or the clerk and say, listen, have we heard back from Dr. So-and-so? The mediation process itself brings with it tremendous high stress negotiations. And I keep emphasizing that because you only have a day, you have client management issues. Now we're trying to do, and I've already done 2 Zoom mediations, which makes it even more difficult in some ways and easier in other ways. So I try to go into these mediations with good briefs, so it's an effective tool for the mediator, but I come with draft minutes of settlement almost all the time, even including the release. So that what happens is, in the point once you cut the deal, you're not worrying about making mistakes in terms of how you're gonna document the deal. That's where big mistakes can happen, certainly in estate litigation. For example, say we miss a beneficiary or we miss an asset. Again, coming back to my earlier tool, which is helpful, is that I've got it there. If we miss a tax point, if we miss other issues, my minutes of settlement, I've already identified and pre-populated a lot of the issues. I typically would do this by putting recitals in the minutes of settlement that identify the issues a little bit, and also obviously the core of the actual deal itself. I don't typically draft. That's something that typically is done at the time. I go with a spreadsheet to all my mediations that allows for all the variables that we can possibly consider. And I'm preparing this mediation 2 weeks before. As you can see, deadlines here are very important. My spreadsheet is, okay, if we get 20% of the estate, what does that mean? If we get 16% of the estate, what does that mean? Sometimes I won't go that granular. I'll go 20, 30, 40. And what does that mean after tax or after expenses, those sorts of things. And if you create the spreadsheet in advance, it's a tool that will pay off in spades. I'll often come to my mediations with a projector. I know it sounds weird, but If I can't go to a facility, if I'm going to one of the like Neeson's or something, then we can do it on a screen. But if I'm going to a place where I'm not sure I could even project it, I'll want to project this. I want the numbers right up on the screen to show the clients what we're actually talking about. Here are the expenses. The other tool I use for mediations is I bring Post-its. So Post-its makes a large, like, you know, size of half the size of me, Post-its that you can stick on the walls. And that helps with visualizing the options in terms of costs, expenses, identifying legal issues, putting up on the risks of each one. All right. So now that we've got ourselves into the mediation, the settlement itself. Now, I have actually, and I have a checklist. Yeah, here, my minutes of settlement checklist at page 12. You can see that I've even got a minutes to settlement checklist before I go into mediation, and I've got a pre-mediation checklist. So before we come to mediation, what am I bringing? Literally, I make sure that I'm bringing colored pens, big Post-its, a projector if I need it, a laptop, you know, the stuff that when you're running out the door, you just want to say to my clerk, hey, did we bring everything? And he or she says, yeah, we have checked the checklist. Again, I'd rather not be at the mediation saying, geez, I wish I had something here with me today. Settlement itself it ties to that as well, the administration of it. So once you've cut the deal, how do you report it out? Well, the post-mediation steps are here again. My report to the client on the mediation. I have a report to the client within 1 week of the mediation as a goal. Some of these are goals as opposed to anything else. Examinations for discovery. I've got my checklist here, which will also allow for lots of variables in terms of its, in terms of the steps to be taken. I have a case map here. Case map comes in really helpfully because it helps me in my preparation as a tool. But again, that's something that somebody can find is personal. Post-examinations,
Ian,
obtaining the transcript. Yes.
just before you go there, while we're on mediations,
Yes.
so I really like the preparation beforehand. An online mediation, because for a while, it doesn't sound like we're going to be able to have the in-person mediation. You mentioned a number of tools that you would otherwise take, but I suppose you could use screen share, et cetera, on a Zoom meeting to make the same visual presentation.
Yes, absolutely. And in fact, it's probably what we're going to have to use because you can't have that physical presence of projecting or using the Post-its. And there's a whiteboard tool on Zoom as well, which is a great tool that really will essentially replace my, not my spreadsheet system, but it will replace my system of projecting or writing out on Post-its.
So as we move into this era of online or Zoom mediations, what thoughts do you have on how we should approach both managing the client, because we're not going to be with the client, and being effective with the other party and with the mediator?
Yeah, it's, you know, I haven't done a lot of them. I did one, coincidentally, just one before Christmas. And the people were in Hong Kong. So my clients were in Hong Kong. And so we had a 12-hour time difference and we had an engagement problem. And then of course we had a problem with engaging counsel in the sense that it was all on Zoom as well. I think the key to the online mediation is, first of all, in terms of client management, we just have to get real. If we don't go to mediation by online now and start booking them now, there's a real live possibility here that we could be months out before we get to a conventional mediation. And even then, I'm not sure how those conventional mediations are going to be. We don't even know if it's going to be a situation of what kind of distancing we're always going to have to maintain. So my approach has been with my clients is I've literally called all my file lists and I've said to my clients, look, this is an opportunity to keep it moving. All of us are a little nervous. We think we're going to do better than we would because in person we think we've got that granular touch, and of course that's probably true. but I'm not sure how true it is. This one I did with Hong Kong was we accommodated 12-hour difference. We said to my client at one point, I said, look, go have a couple hours sleep because, you know, between 2 and 4, we're going to deal with some side issues. One was a tax issue. You got to be at least fresh enough to talk. And I was lucky enough with this client because they really wanted to, they wanted to engage through technology because they saw that it would have been just such a headache to come to Toronto for it. Well, here's the same thing. I mean, we need to engage the technology because we really have no other choice. And so that's helping with the preparation and the client management piece. But I do worry that we're going to lose something with that ability to walk down the hall and say to the opposing counsel, listen, what about this? And are we going to be able to, you know, can't we think of it in these terms? Those kinds of granular touching points with counsel, losing that is not going to be easy to get over. But I just think as all of us are good advocates, we've got to learn to adapt. And it's certainly a fantastic tool as we're doing today. It's online at a level that it is instant and it's recordable. All of the things that really are great assets to a process like this. So I think they're going to be harder days because you're not going to have downtime like you're going to before. But I didn't have any trouble hesitating throughout the day with this one. Now the 12-hour difference had part of it, but lots of times just saying, let's take a break. We'll come back in 10 minutes and go have a coffee. Each of us go to our coffees and so on. So I think I feel very optimistic that they're going to work. But you know, all of us as counsel have to start engaging at a different perspective at a different level.
You think you need to, if you've got a client who's not used to a Zoom and is not used to remembering that they are can be heard by all the parties on the screen without actually, you know, seeing them in the same way that you do when they're present in the room. Do you need to practice with them before?
Yeah, that's a great point. I was so nervous on the one I did with Hong Kong where I set it up through one of the houses with Neeson's, and because they have a way to channel so that only the mediator can, like the mediator controls who's where, and then I can have a side discussion only with the client. And I felt so much better because I thought for sure I was going to mess up and screw up and say something secret that the other side could hear. So I had confidence of letting a third party set it up for us. Because I do worry about that just in terms of the reality that you know, this is technology that someone could not use properly. So practice is crucial, and we did a practice, but we did it through Neeson's first. But I would say it's vital that you do a practice before. And the way I'm doing it is I never do a mediation without a prep meeting with the client. Well, that's my prep meeting, and I'm doing it on Zoom, and I'm using screen share, and I'm showing the sorts of things that I would do at the mediation. And that's forming as part of the practice. But that other point, Chris, is so crucial, and that is that you've got to make sure you've created the meeting in a secret and safe way, a secret as between you and your client in a safe way. And
just to follow up on that, you know, when you would walk into a mediation, you know, they not only know you as the expert in the area, but you've got your own presence and your own personality and your own way of being persuasive in person. Is that going to be different when we're trying to do it online?
I think so. And I think it's going to take a different skill set. That's why I say as advocates, we've got to be training a little differently. I think it's going to, for example, you know, I was on a Zoom call this morning with 24 lawyers, and you could just see on the screen, you know, I did the gallery and the different body language and the engagement. Some people weren't sort of conducting it, like, I'm not sure that I'm setting it up perfect here, but I wanted to have it like seriously online, working out of the house call. But some people might have light coming in on the screen, so it's messing up the visual of you. You might wear white and then you just fade out, those sorts of things. I think those little things that we got a tips, anybody can Google tips on using Zoom, but those little things are going to help engage you in a way that you hadn't thought about before.
Right. Sorry. Why don't you carry on? I just wanted to jump
No,
in
that's
with
great.
these questions.
Yeah. No, please, I'm glad, Chris. Okay, so, I'm getting to the point where now I've got the settlement. Sorry, I've got into the discovery. So examinations for discovery are in its own sort of beast in the sense of some of the steps I want to do. They really are honing in on many of the early steps I've taken, like updating my case map, updating my financials, creating the prep for the client. And now again, I just did a prep for examinations for discoveries that we're going to do in April with the client on Zoom the other day, and it was fine. There was a good discussion. We stayed focused. We didn't, the other thing again, comes back to your point, Chris, about mediation, which worries me a little that we have to be careful to, is taking breaks. I made sure we took a break with the preparation of the examination for discovery with my client, because I broke it up into 2 sessions just because it is, I just found it more intense when you're doing it through Zoom. So that's another, taking the breaks is a little trick or tool that I've used. So look, discoveries are discoveries. My checklist is really just making sure that I'm ready to go. The post-examinations, getting the transcripts and discovery undertakings and refusals. I'll often, at this point, trigger my request to admit. I'm a huge fan of request to admit, and whether they're actually meaningfully used at a trial or not never really bothers me, because what they are is an incredible tool for me to prepare my in-chief. And so I'll often work up a request to admit right after discoveries are done. You can see here, I've got my Evidence Act notices. Some of the core steps I want to take before trial are starting to get pieced into this checklist. And then of course, pre-trial and then the trial itself brings with it its own unique checklist, but also little steps. Like for example, I used to always want to make sure that I could get some sort of meeting room close by. Now that the courthouse doesn't allow you to use the rooms, book the rooms in Toronto, I had made arrangements on a big long trial recently to have access to a friend of mine's office boardroom on breaks that was in the building. Little things like that you think about, and maybe sometimes a little too late once the trial is gone, is going. Again, I've got pretrial briefs, will challenge, pre-populated will challenge pretrial briefs. Not that every story is the same, but the core elements are often. The rest of this is a bit of my steps that I take in terms of some of my own picadillos regarding preparation for trial. I have appeal and file closing steps as well, which I've got in there. Again, that just helps me offsite, make sure that my assistant's on top of that piece of it. And you'll notice here, closing letter to the client. And I'm hoping this has, send a thank you card to the referring lawyer. So that wraps up the retainer, and it wraps up the story for the lawyer. And you've, as from a marketing standpoint, you've touched the lawyer 2 times. One when they came in, and one when it goes out. Well, when it goes out, you need another file, so it's always good to touch base with them. Okay, yeah, sorry.
So Ian, that's very helpful. Let me just ask you a couple of questions if I could, because there are a number of people who have some general and specific questions about this. But first of all, will this slideshow or the slide deck be made available?
Yes.
Okay.
I'm probably going to just make it available as is. I read it again today. People
great.
Just have to bear with me if I've put some stuff in there that is more, as I say, I'm not flogging any products, but the products that I was using.
So here's a question. With regard to the appointment of testamentary guardian for minor children, can the parent write it by hand in Ontario?
Testamentary guardian for minor children. They could do it on a codicil, I guess. They would just have to make sure it's in the codicil, or on a holograph will. They'd have to do it on a holograph will. But it's it's a clause that, you could definitely put it in a holograph will.
So
we also have I'm sorry.
No, you go ahead.
Site a holograph will. So if you were sitting there and your client wanted to just make that change alone, there is the possibility, although it's technically going to be, it's a bit risky, to do a codicil that references the will. And so that might be a scenario where you'd use it. And I put the steps into my, on that webpage initially on some of those steps that are available. And finally, I think the government's probably going to change their rules shortly. We're going to be in a situation that solves a lot of these problems by doing video anyway.
So we should, without asking you about the conversations, we should wait to see what developments there are from the government through the Attorney General.
Yeah.
When you're interviewing people who want to make a will and you're doing it remotely or through Zoom, can you determine testamentary capacity in the same way?
It's a really big problem for us estate lawyers, and we're struggling with it. I think the short answer is yes. And you have to always worry about video, because you don't know who's necessarily in the room and who or who is influencing something from afar. And when I mean afar, from 6 feet away or something like that. Sometimes I'll ask my client to just, if they've got FaceTime, I'll just say, can you just show me around the room what we're dealing with here? I want to confirm no one's nearby, and also I just want to know where you are in the circumstances. It allows me to ask some probing questions about testamentary capacity as well, because I get to say, oh, geez, that's a nice picture of Churchill there. You know, I wonder when was he the prime minister? Something like that. I mean, that's a silly illustration, but the point is, there's the methodology is there. You can record the conversation. It's still not my preferred way to go, but in this day and age right now, in these circumstances, it's the only way to go. And so I have checklists, and I have specific questions that I will use in regard to testing testamentary capacity, undue influence, and I go through it much more carefully, and I make careful notes of those questions in the circumstances. But the short answer is you can do it. Just have to be even that much more vigilant.
Accepting retainer agreements that are signed electronically by the client. Is that, do you do that? Do you think you will be doing that?
I do it. And I think on the retainer agreement level, I think it's the way to go. There's a product that I'm looking into called the Long Pen, which is going to allow some digital signatures. It's sort of like DocuSign as well. So there are some technology tools out there that are probably going to start to surface a little more seriously, but I do accept electronic signatures.
Here's a question. I have a will client who is worried about inviting witnesses to his home. Can the two witnesses be via video as well in today's circumstances, or do they have to be in the presence of the testator? Great
question. Right now, until the act gets changed, it's a fatal blow if you don't have them in the presence of the testator. Or you can use Section 4 with some slight variability. But I think the better practice is this. It's still the law that everyone has to be in the room at the same time, all the witnesses and the testator. There's no secrets here. The government has been lightning fast about looking into changing the definition of in the presence of to consider video being sufficient in these circumstances, in COVID-19 circumstances only. We don't know if that's days away or weeks away, but I expect that that's one of the options that the government's very seriously looking at. But right now, it's I'm saying to my clients, and I've got on my link specific steps in this. I'm saying to my clients, either do a holograph will, and I tell them how to. I offer sending the will to them, and I have a checklist to when circumstances when I'm sending it to them, and then they have family members there present to witness it, or friends that are, if they can corral together the two witnesses, or I'm saying do a holograph will. And there really is right now very limited choice here, and I'm being very careful about. I'm not going to be the one that has a leading case on whether or not you can video a will. I want a legislative change to that. So if I have, last question, and if you don't want to answer this, that's fine. I have a very urgent situation, and it may or may not last until the legislation is changed. Do you think there's any chance the legislation would be retroactive?
to deal with situations that came with the beginning of the government's announcements about distancing? Or is that just a chance that you wouldn't advise we take at the moment?
I worry, I think I wouldn't take it. I wouldn't take the risk. It's going to be very hard to do this retroactively because I think the change will have to be specific enough. I mean, I thought about this scenario. I would say that that's what the holograph will is there for. You have to, I would use that tool. And because I don't know, there's so many problems with making it retroactive that I think the government may not want to do that. But I mean, it'd be great, I guess, in some ways. It's just going to bring a lot of uncertainty into this period of time where people are really, right now, we're stuck with very rigid rules. And if the courts are going to start to say, you know, you can bend those rules, and the legislation has to, and I would be surprised.
Well, Ian, on behalf of Hirsch, this was fantastic. Thank you so much on behalf of all the viewers. Really, really appreciated your time and really appreciated your expertise and your input. You and your colleagues, your input in helping the rules deal with this very unusual and challenging situation. Please, on our behalf, all the best. And to all the viewers here, thank you so much. This will be posted as soon as we can get it ready for that, probably within 24 hours. And next week, we are going at approximately the same time, 1:30, we're going to have Bob Ambrosia on, who is a Massachusetts lawyer who for decades has been a leading advocate of technology in the practice of law, and will be giving us some tips and tricks with key technologies that he would suggest will take us through into the future. So again, thank you so much and all the best.
Thanks, Ian. Thanks, everyone.
Thank you.